Ladies and gentlemen, as we are about to start in 2 minutes, I would like to invite our participants who are still at the booth or those that are still walking around to kindly make your way to the main banquet hall as we will begin shortly. Thank you. For those already here, we thank you for your promptness. Allow me to repeat some of the housekeeping notes for the day. Please ensure that your handphones or your mobile devices are kept on silent or on switched off, as we have an exciting second half of the day. As you can see, I have an amazing co-host that will be sharing the session with you. I would also like to invite all of you to download the slides. There will be a QR code that you're seeing on screen that will lead to the slides that you will have for today's session. And with that are the links to the various different sites and further information that you will need as per what you have requested in the morning. Now, some of the other links to the reports will also be uploaded. So instead of giving you multiple links, we hope to give you one link with all the information that you require. At the same time, there will be a second QR code that will be shared at the end of today, and that will lead you to the feedback form of the session. We kindly invite all of you to give our constructive feedback so that we know how we can improve further sessions.
Okay, start.
Ladies and gentlemen, thank you so much for remaining with us for the second half of the day. To assist with some of our distinguished guests and participants that are just joining us here, fresh from the second half of the day, allow me to quickly recap. The morning session was really an insightful one. We spoke about everything from law reform to access and accessibility. We had interjections on inclusion and inclusivity, voice and meaningful participation. We spoke of determination and moral obligations, and of course, prioritization on how it means to create impact on the ground. Now, for those of you who have just joined us here in the banquet hall, you would have seen a QR code that was flashed earlier. It would be shared again. That will link you to the slides that were shared on the first half of the day, as well as all the slides that will be coming in on the second half of the day as well. We will be sharing a QR code as well at the end of the day, and that will lead you to the feedback form to allow you to give your comprehensive saranan, as we call it, to the sessions that are happening today. Now, for our friends who are not from Malaysia, you may be interested to know that recently we had Keamatan and Gawai, and that was an important event, not only for our friends and family members from Borneo, but there was also a very poignant saying in Iban that says, Segulai sejalai sarak seumai, which talks about not only the strength in unity, but in coming together to make light work. So the more hands make light work. And in the same spirit of coming together for better reforms for children and young persons in the country, what better way to introduce the second half of the day with a new hand? So please give a big round of applause to my host for the second half of the day, Miss Cherry. And so I hand it over to you.
Assalamualaikum. Welcome back, everyone. We hope you enjoyed the food. I'm Cherry from Yayasan Choket, and together with Nadia, we will be navigating the afternoon session with you. Now, we have entered our fourth session, which is Children's Access to Justice and Effective Remedies, example of progressive cases from a CRC standpoint, General Comment 27.
Before we begin our session, let us hear from our child representative. We have Encik Nick Emir Khalif, who is a member of the Child Consultative Council of Suhakam, to give his interventions. Khalif, over to you.
Test.
Would you like to come to the middle of the banquet hall so everyone can see you? Would you like to come to the middle?
Assalamualaikum everyone. So when we hear justice, we often think of equality. Some of us think of police officers solving crimes, or even minorities like people in poverty, or immigrants maybe being uplifted from the unfortunate situations. Now, while all of these visions are good and to some degree accurate, minors and children are often not put in that same picture. They are not the first people that come into your mind. Good evening, everyone, and I would just like to say that I'm very happy and very thankful that I can be a representative of fellow children and also for my community to speak up of issues that are usually put under the rug or issues that are often overlooked or overshadowed. But here's the thing, not every child has this opportunity. Not all children can stand up here and talk about the issues, even children that go through these issues firsthand. Even though policies and laws do arise, and I'm not trying to downplay the policies that have already done good. The main problem for me personally is that from my perspective or from a general viewpoint, most of these policies seem to be mostly convenient for children in urban areas, while children in rural areas or underdeveloped countries are still being forced into child labor, working in the mines, in sweatshops. Some of them are being forced to marry off, like in India, for example. And I think that's still a very big problem when the privilege of these policies are only centralized towards cities. So I hope that today's session can give a concrete answer as to how all children can access these benefits. Thank you.
Thank you very much. You have Nick Emir Khalif, a member of the Child Consultative Council. So with that, it is my esteemed pleasure to hand over the session to a very abled and important person and a dear friend. We have Yang Berusaha Puan Melissa Akhir, Suhakam Commissioner, also the Chair of the Law and Reform Policy of Suhakam. Over to you, Melissa.
Honorable Professors, Honorable YBs, MPs, and our respected international invitees and speakers. May I invite, together with me, if we can invite Yang Mulia Tun Tunku Maimun to the stage, please, before I read out the bio. A round of applause. Professor Tuan Lifat, that we have heard of before, let's invite him again to the stage. And the highlight of our session today, if we can invite Miss Jessie Lee. Thank you so much for coming here in this session. We heard our most excellent child intervener just now, and now we will unpack more regarding the issue of access to justice, as well as what does remedies mean. I am also told with our sign language interpreters, we are supposed to unpack and break down the legal phrases so that it is more layperson friendly and also child friendly, if possible. Okay, without further ado, we have met Professor Tuan Lifat, heard about his background a little bit, but I would like to add that Prof. Tuan has done quite extensive work around the world regarding children in the justice system, formerly called juvenile justice or children in conflict of the law, and also on access to justice itself within the draft general comments that we heard of. More importantly, Prof. Tuan advises the Netherlands Parliament a lot. He was telling me he goes up and down to Parliament and sees other MPs that he highly respects. So thank you for being with us again, Prof. Tuan. And also, I think quite popular in this room with many opportunities to take photos of Yang Mulia Tun Tengku Maimun. Of course, we know her as the Chief Justice of Malaysia from 2019 until her retirement in 2025. Tun Maimun is the first woman to hold the nation's highest judicial office. And proudly, during her tenure, she had many landmark constitutional decisions, cases on gender equality that were award-winning, judicial independence cases, anti-corruption cases, and also clarity on federal and state legislative powers. Now, following Tun's retirement, she was appointed Professor of Practice, correct, yeah, Prof? And the inaugural holder of the Royal Chair in Integrity and Good Governance at the National University of Malaysia, or UKM. A round of applause for Yang Mulia Tun Maimun. For Ms. Jessie Lee, we have here particularly the expert regarding her own community. She has spoken, yes, a round of applause for Jessie. Not just on children's rights in general, but also all the intersectionalities of children's rights, especially with a particular passion on children with disabilities. So please, one warm round of applause for Jessie. Okay, let's do a first round. We have, I'm told, around 15 minutes. If we can invite Prof. Tuan first, if you can walk us through a little bit. When we say access to justice and we say there's a general comment, what does that actually mean? Could you walk us a bit through that? And on effective remedies, effective how, if you can walk us through that. Thank you, Prof.
All right, thank you very much, Melissa, and wonderful to see you back after lunch. When when we talk about access to justice, people tend to look at the criminal justice for children, but that is only part of it. So access to justice, and I talked about it a little bit before the break, is really about offering access to remedies for rights violations. And what is interesting is that that is an essential element of an effective human rights protection system. Earlier on, we were talking about general comment number 5 of the Committee on the Rights of the Child, in which it explains the general measures of implementation. And there the committee notes that for rights to have meaning, effective remedies must be available. And that is a very important message. And it has not received so much attention until a few years ago. But it's in a way, it has been for a long time the missing link between law in the books and law in action. And access to justice, if you really break it down, it is essentially about offering an avenue to claim rights, to enforce rights, or to seek remedies for rights violations. And rights violations can be, deliberate or intended rights violations, but it can also be inaction, for example. So not living up to obligations that flow from rights. So, and that's essentially what access to justice has to offer to children, is in a way, avenues for children to hold those who are accountable to account. So for rights to have meaning, and I'm quoting the Committee on the Rights of the Child again, effective remedies must be available. And that is something that has received a lot of attention internationally over the past 5 to 10 years. So we see now that access to justice for children is seen as part of the children's rights agenda. And also, it's also embedded in the Sustainable Development Goals. So if you look at Goal 16 of the Sustainable Development Agenda, which is about peace and building institutions that can promote peace and justice, access to justice for everyone is seen as a critical element of development. So a 2030 goal, so to say, to invest in access to justice mechanisms, and that is equally relevant for children. Yet, when we talk about children, we see that access to justice is very often very far away. And that has a number of reasons. There are some specific barriers that stand in the way of for children of accessing justice. And there are basically 3 categories of barriers. One is legal barriers, the second one is more practical barriers, and the third one is what we call maybe social or cultural barriers. Now let me go quickly through them. So the first one is legal. And what is that? For children often have no legal access. So often domestic legislation is based on the idea that when it comes to access to justice, that children depend on others, in particular those who are legally responsible for them. So parents, in other words, have to represent their children in vindicating or claiming rights. And that is true in many civil codes around the world. And that is not necessarily a problem because parents can represent their children. But there may also be instances where there is a problem. And it also shows in a way that we don't recognize children's procedural rights to the same extent as we do with human beings in general. So that's an issue of concern. Sometimes there is legal barriers related to age and sometimes also to topics and themes. But in general, this is the way we approach children when it comes to access to justice, is that we don't give them a standalone right to access remedies if they need them. And I gave you the example from South Africa, which used the Children's Act to basically change that and say, listen, children have legal standing. if they have a right to go to and seek justice, then they have legal standing. So that's provided for by the Children's Act of South Africa, just an example. The second category are practical barriers. So justice systems are often very complex, and they are inaccessible to many, not just children, but certainly also for children. Justice systems are often very unkind, unfriendly, inaccessible, difficult to maneuver, right? So that's for adults already the case, but for children even more so. They were certainly not designed for children. So for children, there are many practical barriers related to language, to the complexity of the procedures, but also the absence of legal support. So legal assistance and legal aid are critical elements for children to get access to justice. And it's seen also as a reason to invest in free legal aid and supportive mechanisms to help children to seek justice. And that's also an issue of the quality of the support that is offered to children, because lawyers have to understand what it requires to assist children in the context of justice. And that's something that relates to education and training, of course. So there's a lot to be considered when we talk about the practical barriers for children to access justice. And there's another implication of this particular barrier, and that relates to the avenues of justice, is that we should not only think of the classical judicial ways and avenues. We should also think about maybe avenues that are easier to get access to, like going to an NHRI, for example, a children's ombudsperson, Suhakam. Maybe complaint mechanisms closer to where children are and live. Maybe mediation processes in the direct vicinity of children. So there's justice avenues could have multiple forms, and it's also really important to recognize that, because it's not just about the judicial avenue to seek remedies. Doesn't take away the fact that judicial means could be very, very relevant, because also of the legal value of judicial mechanisms in your society. But definitely access to justice means access to many more avenues than just the classical judicial avenues. The third barrier that children encounter, and this is coming also out of our research, but also research done by UNICEF, for example, globally, and also specifically in Central Asia, a very good example of a piece of research that informed us a lot about access to justice, is this component of cultural or social barriers. And that is something that is very challenging. What does it mean? It basically means that cultural norms stand in the way of recognizing children's access to justice. And it starts by a failure to recognize that children have rights. And if you don't recognize that, why would you need access to justice, right? So denying children their rights is also a barrier to access to justice. Other examples that have a cultural background or a local contextual background are related to the assumption that children are not expected to speak up to the powerful or to the elderly. So accessing justice basically means that you speak up against the decisions that impact you, taken by adults, maybe by community leaders, maybe by others, and that is simply not accepted. So that's another barrier of, engaging with access to justice for children. And another one is related to discrimination between, for example, boys and girls. So boys may have means to access justice, while girls may not have it. So these are three examples of where local contexts, cultural norms, social realities stand in the way of granting children access to justice, and it's something to think about. If we are serious about access to justice, how can we overcome these different kinds of barriers that are particularly relevant for children? So the Committee on the Rights of the Child decided to step into the arena of access to justice and decided to develop a special general comment on access to justice. And that's on its way. It's called General Comment number 27, and it will be about access to justice for children and effective remedies. And it will zoom in on various elements. So the accessibility of justice avenues, accommodation of children when they have reached out to authorities to seek remedies, the responsiveness of authorities to respond to claims or complaints made by children. And it's also about the actual remedies provided to children. Because that's very much about what we understand when it comes to justice. What does justice mean? And it was already raised just after lunch. What does justice mean? We have to understand what justice means for children, what they expect from it, when they feel that justice is delivered. And that relates to, Melissa, one of your points, and that is about, what are effective remedies, right? And there is different examples that we could study to see what remedies could look like. But what we see overall is that remedies could be very individual. So, for example, there was a case brought to the Committee on the Rights of a Child under the complaint mechanism, the international complaint mechanism. And that case was very much about a girl who was a migrant coming from Africa to Spain. And that girl was undocumented. And because of that, she could not get access to school, which was essentially an administrative thing. So she just needed to be registered, and then she could go to school. And she didn't get access to school, and there was no way she could force herself into the educational system. So she lodged a complaint to the Committee on the Rights of a Child. And the Committee on the Rights of a Child, under the procedure, reached out to Spain. And then things started to move. So clearly the complaint was a way for Spain to rethink its position. And Spain ultimately granted the girl access to the school. And they changed the administrative system accordingly, and it was solved in a way. The complaint was not pursued, so it was not resulting in a decision by the committee. It was already dealt with at an earlier stage. But the committee, of course, expressed its appreciation to the Spanish authorities for moving swiftly in response to the dire need of this girl to go to school. And that was a very individual remedy for that particular girl in relation to education. But it had so much more impact because it also showed that children who are undocumented or refugees or migrants, not from Spain, were entitled to go to school. So it had a bigger policy implication, that one case. And that's what we see a lot, is that remedies for children are often not just for the individual child, but also for a whole group of children, because they help us to give substance to the human rights obligations that we have for all children. And you see that courts tend to look at cases like that. So they are often invited to look at cases individually because there's a complaint or a specific issue at stake, but the broader implications are really important to recognize. So that is something that I would like to share also in my intervention, and I'm conscious of the time, is that access to justice for children is meaningful for individual children, but it is even more meaningful for all the other children. And what is interesting me is if there's one group of citizens in our society that understands this, it's children. Children often lodge complaints or communications because of injustice. And then they are not necessarily so worried about their own experience, but they don't want it to happen again. And that's why they are interested in access to justice. So we need to understand what drives them, what it means for them, and then we will be able to deliver. So thank you for giving me the opportunity, but I hope this sets the scene.
Thank you so much, Prof. Ton. And on that last note, I'm reminded because we have parliamentarians here, if we have officers from the ministries here, that we would consider being part of the individual communications to the CRC committee to bring the voices of the child forward. Thank you so much for your session, your presentation just now. If we could invite now Yang Mulia Tunku Maimun, bringing it forward from all the examples from Spain, and bringing it more to some of your celebrated court judgments, and one of which had deeply served Article 9 of the Convention on the Rights of the Child. Children in general should not be separated from their parents. So now, bringing it to the perspective of a child that may be impacted before, I will name her Prasana Diksa. So Prasana Diksa, from her eyes, if you could carry some of your wisdom towards us and all of the parliamentarians here on whether her child right to participate, her right to develop together with her parents or her mother, and her evolving capacities. How does she get her views get considered in the long process of judicial court judgments? So if you could share any of your perspectives now, having seen how the judicial process operates in Malaysia. Over to you, Yang Mulia Tun Maimun.
Thank you, Melissa. It's quite difficult to comment on something which is so hypothetical. We really don't know what has happened to Prasana Diksa, who raised her, whether she has any idea of who her mother is, if at all, that she knows that she has been separated from the mother, and why isn't her mother with her? Really, we don't know. So in that sense, it's quite difficult for me to give comments on her evolving capacities and her participation in the court process throughout the years. But I wish to share, I think this is also in relation when we talk about the child's right to participate. It is actually linked to the two concepts that was mentioned earlier, access to justice and effective remedies. Access to justice, simply put, when a person feels that he is being wronged, his rights are being violated by whoever, so he comes to the court to seek a relief or to ask the court to undo the wrong that has been done to him. So basically, access to the court, access to justice is, we are talking about access to the court. I mean, let's put aside the other alternative mechanism. So when we talk about access to justice, it's access to the court. And when we talk about remedies, in fact, access to justice is inextricably linked to remedies. Because if you don't have access to the courts, then the courts would not be able to grant you any remedy at all. So when we look at Indira Gandhi's case, and the other thing is this, whatever that the courts grant, the remedies that the courts grant, will correspond to what the parties sought. Because ours is an adversarial system, meaning to say the judge is acting like a referee. If two parties want to fight, they will fight. The referee is just there, making sure that the rules are being adhered to. But if, for example, one of the parties concede defeat and wants to withdraw the case, for example, then that's how we have cases being discontinued and so on and so forth. So in an adversarial system, the courts should not be making a case out for any of the parties. Meaning to say, whatever that you want the court to give you, if you want A, B, and C, for example, then you must ask the court for A, B, and C. If you ask for A, B, and C, the reliefs, you cannot expect the court to give you D, E, and F. So that is basic that I think the public must know about how the court system works. So in a way, the judges are constrained or rather confined to the basic principles of the law, and there comes the problem that we are looking at individual cases. So because that is how we are supposed, that is the framework that we are supposed to work on. We decide on the matters or issues that are before us. And if the parties are A, B, and C, so the relief that will be granted by the court would be in relation to those parties. Okay, coming back to Indira Gandhi's case, whether or not Prasanna Diksha has right to participate, I think generally in cases involving custody of a child, the courts will generally ask the child to be present and will get their views, or rather hear from them, whether they prefer to be with the father or the mother. That is generally the case. But in this instance, Prasanna Diksha was nowhere to be found. She was, effectively abducted, whatever term that we want to describe her situation. But the point is, she was not available before the court. But that said, I would say that her interest was taken into consideration when the judges decided the matters involving her. So what happened in Indira Gandhi, there were several issues. There were issues relating to the unilateral conversion to Islam. There were issues of custody, of course. And when the courts decided in the favor of Indira Gandhi, the mother, and the father refused to obey the court order, the court granted the mother a contempt order, meaning to say, when the husband refused to comply with the court order, committal proceedings was initiated by Indira Gandhi, and the court was with her, granted her an order for the husband to be committed for contempt of court. But this order has to be served on the husband, and I believe until now, the order has not been served. Okay, and then when Indira Gandhi obtained the custody order of the child, and the husband also, of course, I think this is in the public domain, the husband also obtained custody order from the Sharia court for the custody of the child, when the law in our country is established that for civil marriages, when one party to that civil marriage converts to Islam, whatever issues arising out of that civil marriage must be resolved in the civil court. This principle is established long ago. It has been established, but somehow the husband went to the Sharia court and got a custody order also. So seemingly there is a conflict of jurisdiction, but in actual fact there's none, because the jurisdiction of the Sharia court does not cover this civil marriage. That aside, what happened in Indira Gandhi was, all along the judges, or rather the courts, gave judgments in favor of her. But justice failed. Why? Not because the judges applied the wrong principle of law, not because the law was not enough to protect the interests of Indira Gandhi or her child, but because there was a structural and an institutional reluctance or refusal or failure to serve the valid court orders on the husband. So that's the real issue in Indira Gandhi's case. I hope that answers the question.
And how about now for Prasanna Diksha? Because she's past the age of 18, we wanted to access, because Malaysia has courts for children, for example. And although Malaysia is just a member of the Hague Convention on abduction cases, but there are situations where parties can bring to the magistrate to cause the child to be brought. Like what you mentioned, Yang Mulia Tun, the child was not brought before the court. The court can't even look into the welfare of the child, the best interests of Prasanna Diksha as a child. So if we can advise Parliament, for example, how do you scrutinize all cases? Because in Malaysia, the Federal Constitution says Article 8, no discrimination on the basis of someone's ethnic background or whatever their identity may be. So if we say that, how do we make sure equality before the law for children as part of their access to justice? And of course to remedy the situation so they have access to their parents. Okay, over back to you.
Well, I think if I were to propose to the parliamentarians here, I think there should also be a scrutiny on why is it that the court order has not been enforced? What exactly is the problem that the child could not be located and returned to Indira Gandhi, and why is it that the police refused to enforce the court order? So perhaps there should be a scrutiny on what exactly is the problem, because it is quite impossible that you could not locate somebody who is alive and kicking wherever it is, because I have high regard for our enforcement officers. I think they are very competent and efficient. So perhaps the parliamentarians should be looking and make them accountable. What exactly is it that resulted in this kind of problem concerning Indira Gandhi when she has all the court orders in her favor, but at the end of the day we see that justice is not served insofar as she and her child is concerned. And more importantly, I think for the parliamentarians to think about is this: are we undermining the law in this regard? What good does the court do then if judgments have been given, but it is simply or deliberately not enforced? Are we not undermining the law, or are we? Can we say for certain that we are in fact upholding the law, or are we, unconsciously, in fact, undermining the law? Thank you.
Thank you so much, Maimun. And then also now anchoring the entire conversation, because again, nothing about us without us, right? So speaking to someone from the community, again, on the idea of justice, but for the persons actually walking through it, through the years of when you're growing up. Anything that you would like to highlight in addition to what has been said? There's some concepts, there's some legal terminology, but how do we make it real? And what would you like to say to parliamentarians to ensure fairness and justice for children and remedies that work for children? Over to you, Jess.
Thank you, Melissa, for that question. I just want to thank everyone for coming today. Thank you for this opportunity. It's an absolute honor. And honestly, I think the best way to start off is exactly how my friend Khalif started off, right? We all know justice as laws, courts, cases, all the crazy stuff, right? But then, it is crazy. But the access to it is completely different, right? It's not just justice anymore. It's about, can you really go up and get the support that you need? And instead of, using terminology that's very long and lengthy and kind of bombastic, I just want to boil it down to a more simpler question. If I was a child going through a case, if something had happened to me, can I receive the support? Can I receive the help that I deserve and that I am owed to when I'm going through something? Will I be listened to? Will I be taken care for? Will I be treated, not as a child, but as someone that is a rights holder? Will I be there in court as someone that is not seen as, oh, they're a child, so maybe they don't know what's happening, but will I be seen as someone that knows what is going on and that I have a right to make a decision for what's good for myself? And your question was about how can processes be better for children, right? For the parliamentarians, I think the processes that you can do is what you've already been told, right? Listen to children, consult them, talk to NGOs that always work with children, and that's all great, right? But the thing is that what I'm realizing is we always tell you the same thing, but we don't see you doing the said thing. I always come to Parliament. I always follow other NGOs to come and join meetings. I always watch the interviews, always watch the symposiums going on. And in all honesty, all the answers are the same, right? Consult children, bring them into the room, make sure they're consulted properly, make sure there's safeguarding, make sure they feel safe, make sure they feel listened to. But then at the end, right, there's nothing that really happens. There's no outcome. There's no, yay, good ending story. There's no moral of the day. At the end of the day, it just kind of seems like you're ticking a box, right? It feels like you're just doing it because you have to do it, not because you want to do it. And so if you guys really want to consult children, I think the best way to go about it is already consulting the NGOs in the room who have worked with children countless of times, like Suhakam for one. Mao is also a great one. I've worked with them for so long, and they're so incredible. They're so good at their jobs. I love every consultation I have with them. And if you're not willing to talk with them, then personally, I think that is something you need to improve on. I think that is something that you need to kind of look deep down in yourself and think, why are you not willing to take opinions from NGOs who have probably done more work closer onto the ground with children these days, And I honestly think that even if you don't have the time, there is no excuse for that. Having no time just means that you don't want to find the time to consult children. You don't think it's important. You don't think that they deserve your time. Because honestly, in the room today, you can consult any of our children. We have children from YCK, we have children from Suhakam, some young youth adults from UNICEF YPAC. We have all young people and young children here today. So even if you don't have time out of your day to consult them on a different day, on a different week, on a different month, you can talk to them right here, right now in the room. That's all.
A bit more unpacking, because you say if they want to follow through. Let's say they're consulting you now, and they're asking, what do you visualize that should change, the actual concrete action, other than just the same topics? But after this, what can parliamentarians do? What can the government do? What can civil society do that you think concretely? Maybe some steps you want to suggest, then children feel that you are moving together and not an afterthought, right? So maybe would you like to suggest some scenarios, some steps forward? Yeah.
I think the only thing I can suggest is really working with us from the beginning. And when I mean from the beginning, not as in, oh, okay, you're planning this event already, and then you invite children. I mean, when you are planning that event, in that moment, you have children in there to see how they feel about the event themselves. Because you can't really hold something for someone else and then expect them to immediately like it because it's for them. That's not how it works, right? You wouldn't have a birthday party and then the theme is red, but then their favorite color is blue. It doesn't make sense, right? It's a very simple example, but it makes complete sense. And when you're going through the whole process with them, you have to consult them. You have to make sure that they really do feel like their opinions are 100% part of the solution. You have to make sure that they do see the outcome of it, that they do see that their opinions have really been included into the solution. Because most of these times when children are consulted, right, they're consulted at the end of the event, they're consulted at the end of decision making, so they've already written the laws, they've already said that this is what's going to happen, and then only when children come forward and complain, that's when suddenly all the parliamentarians are like, oh, actually, okay, we're going to consult you now. But then even when they consult you, at the end, right, they just kind of shake your hand and then they walk away. It's okay, you can laugh. I know it's real. But that's the thing, right? Like, we have to realize that it's not okay for them to just shake our hands and be like, okay, thanks. Because as young advocates, right, I can 100% tell you that we put our 150% effort into trying to give you the best solutions, best opinions, the both positive and negative sides. And then if at the end, all we get is a handshake and thanks for coming, and then we don't see anything, the outcome, we don't see anything that's really fixed, then what really is the point? So yeah, at the end, conclusion is, if you really want to work with children, work with them from A to Z. Work with them from the beginning to the end. Work with them even when it's a post-mortem meeting.
And seeking your guidance again, if we have a law, let's say it's covering legal aid for children, from the start when you write the law, speak with the children who might be seeking legal aid, right? Okay, so for parliamentarians, they should look at that. For the court cases, maybe if there's anything that you have received from the community that you would like to highlight, any particular communities that parliamentarians must pay special attention to.
I think personally, I think there's one community we're all like looking at right now. I mean, they're right there at the site. They're at the visual right there. It's our, OKU community, but it's not just OKU. It's our refugees. It's our undocumented. It's, those who are not privileged, those who are not in the room today with us, those who cannot have their voice out because for safety reasons, for health reasons, for all types of reasons, right? And in my opinion, I've always thought that those communities are the ones that need the most help. Those are the ones that we need to focus on. And I understand that working with urban areas might be easier because of transportation, right? We have our train. It might be easier because, the places are closer. The language is easier to understand. But then if that's the case, right, then you're just understanding one majority. You're not understanding the whole minority, right? Because Malaysia is not made up of one group. It's made of a million different groups. It's made of hundreds of different ethnics, like races, culture, and when you're only focusing on one group, then you only have one solution for one type of person.
So thank you for that. And taking the spirit of what has just been advised, we're going to go children first for the rounding up, okay? So if right now, in the current climate, we're thinking maybe there's a slight state election fever. Some states have been dissolved. Their state assemblies. What do you want persons who are clamoring for votes, who are supposed to look into the interests of including families and the children in the areas where they want to serve at for the rakyat, for the people? Okay, what would you say is the most urgent area on access to justice and remedies that work for children? One area that you would like to propose. Maybe that could be the concluding part.
I think one area would be communication. Because it sounds simple. I mean, it's just communication, right? But communicating is really not just about words. It's about your body language. It's about how you behave. And it's something that I think a lot of people tend to miss out upon because children are actually very attentive. They really pay attention to your every move. As long as you have one difference in your facial expression, the child's going to assume that you're upset, that you think this is a burden, that this is too boring to deal with, that this is not worth their time. And because of that, right, when you don't take notice or when you're not trained on how to deal with children, they're gonna be more scared to talk to you. There's not gonna be proper justice. There's gonna be things that mess up the process because communication, if not most times, is one of the best tools we have as people, but it's also a tool that we can weaponize a lot. So if it is possible, I would love to ask not just like the court, the parliamentarians, but everyone in the room to always not just think before what you say, but to also just think about what is going to be the after effect when you say something. What, like, is your expression right? Is your behavior right? Like, who are you talking to? Who are you dealing with? Because at the end of the day, right, you could do something so small, but that small thing will affect their lives forever.
And yes. And communication that's consistent, right? And followed by action after it's been communicated to the rakyat. Okay, thank you so much for giving that ground-up perspective and from children to the grown-ups who are supposed to carry out their duties. Thank you so much. Okay, moving to Yang Mulia Tun. Again, same question. If you have one point you think is most urgent for us to look into for the interest of all. Yeah.
I think we should all eliminate, if any, subconscious or unconscious or implicit bias that we have against us. I mean, from my perspective, sometimes we are not, perhaps we're not aware that, deep inside us, there is some sort of a bias in dealing with certain issues. So I think we all should look inside us, and if there's any bias in terms of when we talk about children's rights, perhaps, when we look at how we should be treating them and what kind of justice do we want to dispense to them as, when certain issues crop up. So perhaps we should put aside our religious and personal perspectives. Thank you.
Similarly, Prof, anything we can pursue in terms of good practice that you think one area that we can try?
I would like to encourage Malaysia to become a party to the optional protocol on a communications procedure for children. And that may sound like something far away, but it is, if Malaysia does that, and I would really like to see that happening, then it would be a leading country in the Southeast Asian region, and it can join the growing global awareness around access to justice for children. And it will really help you also to find more guidance on how to make child rights work in Malaysia. So it's not just a mechanism that that is about what you do not do well. It can also be a stimulus to do even better. And I would really like to see Malaysia becoming part of that global group, and that would really be good ultimately also for the children in Malaysia. So thank you.
Thank you so much for that summing up. A big round of applause to our panelists for their interventions. I am checking for one of the usually most awaited areas, which is the question and answer session, and I would like to be consistent. Whether we can invite any children or young persons to come forward first, to have access to the mic, to have your voices listened to first. May I invite any children and young persons in the room who would like to pose any questions to any of our panelists?
Hello.
All right. Hello. My name is Emlyn. I'm from CCC, Suakam. So I think it's actually something that there's something a little bit that I think is a bit overlooked here, which is the fact that that children nowadays, the society we live in right now, they actually have been embedded with the culture, that they think that their opinions are something that is less worthy or not as much as they think they are actually to their full potential. So what I mean by this is like when a children faces a problem, the first thing they think about is not to solve it, but they think that this is something that the adults should do for me. Or they also think that this is something that I can't do myself and I need to depend on someone to do so. So this is the society that we live in today, where children fight, they give up before they actually fight. So my question is simple. How do you exactly plan to promote a society or sort of mold this reform to, whether it be law or policy, to be more flexible or meaningful for children to actually understand that their rights and issues actually matter, and for that voice to actually be led with action to tackle their problems? Thank you.
Thank you for the question. And of course, whether we want to ask from the rights holders' perspective first, before we get any other responses, would you like to take the...
I mean, I completely understand your situation and question, Emmeline. I think it's kind of like, I guess you would say the adult word for it is fear-mongering, or kind of that institutionalized pressure, because it's been so common, right? Like you said, that children these days think that they need to depend on their parents, and I think sort of the reason because of that is because in nicer ways, some parents still kind of baby their kids, even when their kids are already very big ages. And understand, it is your kid, right? It's your baby. You want to take care of them. But when someone, doesn't learn, when you don't touch the hot oven, how will you know it's hot, right? How will you know to take your hand away? How will you know that's painful, right? And that's the same concept. When children don't learn, they're never going to understand what's right, what's wrong. And so your question was about the processes, right? How we can ensure how to follow through this. I think it's just like what I said before, right? Communication, staying consistent, making sure that the child knows what's happening through every single process, not just updating them like every once a month, but making sure that they understand this is what's happening, using language that they understand, using spaces that they feel comfortable in.
So the process matters, and communication throughout the process matters. Okay, quick observations also on the adult accountability part of things, if you want to respond.
I just want to say this in terms of whatever policies that will be introduced or will be implemented. That is of course within the domain of the legislature and the executive. But I think I just want to share one thing that the judiciary has done in terms of making sure that the public knows the processes, or rather, sort of making, bridging the gap or the bridge between the court and the community, and especially for the young people, the children, the school children. So my predecessor, Tun Richard Malanjum, started a program called My C2C, My Court to Classroom. So we selected particular schools, and judges will go there and speak to the children. And that has sort of expanded with the children coming to the Palace of Justice, and we will share with them whatever needs to be shared in terms of maybe cases involving juveniles and so on and so forth. So I think I want the audience to know that there are initiatives by the judiciary to engage with the young people and the school children in particular.
Would you like to respond? Yeah.
Yes, I thank you very much for the question. I think the word culture was already mentioned a number of times, but in a positive way, culture of children's rights, of respect for children's rights, also cannot do without education and real empowerment. So I think that is an absolute critical step for us to consider. How can we make sure that everything that we develop at the legislative level, at a policy level, judicial decisions, can land on fertile ground, right? And I think that is a matter of communication, but it's also a matter of educating communities and also its citizens, including children. And what you often see is that we talk a lot about the right to be heard and participation, but children are not equipped to participate. They are not expected to participate, so why would you equip them, right? So, and then there is a big role for us to play in terms of education and empowerment. And one of the powerful messages that came out of the Office of the High Commissioner for Human Rights when it presented its first study on children's access to justice is that access to justice is also very much about empowerment. It has to have a foundation. Justice has to have a foundation, and that is to be built at the community level together with community members and education. So education is not only about language or mathematical skills, it's also about positioning children in your society and making sure that they are empowered and resilient and can also participate in that regard effectively. So that would be my reflection on your very good question. Thank you.
Thank you so much for the question. And we have the point regarding when we have the process, when we have laws being debated, the town halls, where are the children in the process? Okay. So quickly, the next question, if we can invite. Sorry for keeping you waiting there for a while. Go ahead.
Hi, my name is Telford Ingan Tan. I am from Sarawak. I'm also currently a law student at Help University doing my Year 1 UK degree transfer. And I have a question for Yang Mulia Tengku. And my question is as follows. In a published paper by the International Journal of Social Policy and Society, it is seen that the settlement rates for family courts are high. And in my opinion, this is belief that the courts encourage settlement due to it reducing the backlogs of courts, reducing hostility, and it also, in theory, encourages a middle ground between both adversarial parties. But where children are concerned in these settlements, such as ADR being used, negotiations, arbitrations, where children are concerned in these negotiations, where they are not the real decision makers in these settlements, how can we ensure that there is no imbalance of power in these negotiations? And what safeguards can the courts ensure by encouraging these negotiations that these final decisions are sound and ultimately places the rights of the child first and not the rights of the child being bargained away due to the power imbalance of the adults. Thank you.
Thank you. You see, when we talk about negotiations, actually it is a voluntary, a step taken voluntarily by the parties to sit down, negotiate, and come to a settlement. So in that sense, the court is sort of out of the picture. Because when parties settle, it is entirely up to them on what are the terms that they can agree. So that could include matrimonial property, custody of the child, and so on and so forth. So in that sense, perhaps, unfortunately, the court would not be monitoring whether the interests of the child will be protected or otherwise, because when the parties sit down to negotiate and settle, it would be entirely up to the parties to see how their own interests or the respective interests of the father and the mother and also the children would be taken care of. So I don't think that I could give a definite answer or an assurance that the courts or the judges will make sure that the interests of the children will be protected and see that they have, they are rather involved in the decision, whatever decision taken in that negotiation, because when we talk about negotiation, as I was saying, the court is actually out of the picture. So only when they reach a settlement and they have agreed on the terms, then they will come back to the court for the terms to be recorded. But as far as the judges or the courts are concerned, we will take it in the spirit that parties negotiate and settle, having considered the best interest of the child, of course, and the interest of everyone is taken care of. Thank you.
As the law professor to a law student, did you want to reply? Or
no, just to add, I think this was very accurate, of course, but I think it basically means that the responsibility for including the best interest of the child into and taking into consideration is then on the parties, right? And then it's up to the judicial system to carefully scrutinize that. So, and that is, in my view, that should not be a marginal test. It should really be about, okay, how did you engage with the best interest of the child? What was the result of that engagement? And also, for example, to what extent have children been able to influence that? So participation of children in that particular part. But the burden is then on the parties. But critical, I think, to include children's rights there as well.
Thank you, Professor. We only have 4 minutes left. Next question, please.
Assalamualaikum and good afternoon. My name is Azira. I'm a practicing lawyer based in KL, Selangor. I'll try to be brief. My first is regarding access to justice for juvenile offenders. So, as part of the legal aid services, YBJK, Yayasan Bantuan Guaman Kebangsaan and Legal Aid Services for the state of Selangor, I handle cases that are perpetrated by children. And I find that irrespective of what they are accused of, when they are still under remand, when they're just being under investigation by police, I find that they've always felt intimidated and not having any access to information for them. And also sometimes when they are brought to court, I will see them young chained along with adults. I'm well aware this is normally go to channel. I have gone through all the proper channels, but this is for the policymakers' benefit. So you will find children young chained along with adult offenders. In some situations, they will come to me with injuries from the treatment or during arrest or detention, and they will show me injuries. And I would like to ask policymakers, based on my own experience and self-reflection as well, that please do not overlook juvenile offenders, whether they are convicted of any offences, be a teen mother convicted of infanticide or just someone who is organised crime or whichever. They are still children and their experiences under detention matters. And I find that our justice system is not empathetic towards children that should by right have the opportunity to be rehabilitated, to become better human beings. That's one. The second part is in terms of when assisting survivors. I don't like calling survivors victims because I want them to see themselves as able to move forward past the incidents that they go through. So they are not believed or sometimes dismissed completely. And they are sometimes intimidated by the officials. I will not name them specifically, but you get what I mean. Sexual abuse survivors, domestic violence survivors, sometimes neglect survivors. They are dismissed or intimidated not into carrying out their police report or withdrawing it completely because to them it's unnecessary work for certain officials.
Sorry, the question. We have 1
so,
minute left.
Okay, sorry. So
the
my question is, what do you feel can be further addressed and be aware of by policymakers in terms of in their own constituents that can actually assist more in carrying out the interests of the children? Thank you.
Children, the justice system and survivors of crime and in need of child protection. Any quick remarks?
Very quick is information. So you also refer to information. Information is absolutely critical because it's also about managing expectations and also providing guidance for additional services. Victims seldomly only need something from the criminal justice system. They have other needs as well. So information is absolutely key. So if we talk about access to justice for children, we need to think about how children can understand how to access justice, how to access services, but also what to expect from it and where they can find help to get a better understanding of what is going on. And that is not something in just for specifically for victims, not just something for the shorter term, it's also longer term because victims may need time to before they can actually say something or feel something or actually find help. So sometimes that's much later. So we have to really understand that. But information is absolutely key.
Thank you. Next, because I have the red alarm now that we have actually run out of time. Can we just have the last question, please? And then maybe we can fold the question into the next session.
Okay. Thank you, Madam Moderator. I'm called to respond to Yang Mulia Tun Tengku Maimuna.
Yeah. Could we have your question? Because we're out of time. We just need the question. Yeah.
How to unlock the legal structure, beside legislature, executive and judiciary, how to unlock the legal, structural and institutional obstacle where the authority or bodies reluctantly to enforce justice, be it justice for children or justice in general. My suggestion is that Yang Mulia Tun, to move forward is for the relevant bodies, parliament, NGOs, Islamic authorities and relevant bodies to engage aggressively to find the final solution. For example, Christianity and Muslim have clearly mentioned that non-exploitation of humankind. I just Googled early on. There's a special word here. Anyone who does not show mercy to our children or no acknowledge the right of our old people is not one of us. So we can use that as a benchmark for us to move forward. Thank you.
Thank you. I agree.
Thank you so much. And can we have a round of applause for Khalif as the intervener, Jessie, Yang Mulia Tun Maimun, and Prof. Ton. Thank you so much for your attention in this session. Thank you so much, panelists. Over to you, MC.
Thank you so much, Melissa. Wow. I want to turn to my lovely co-host. So, Cherry, what did you think about the last session?
It was so interesting, but I love the way that Dr. Ton Lifer explaining about different kind of barrier and different perspective for adults and children. So we have to understand both ways to not misunderstanding about the things. So I love the way he explaining it.
Definitely, and I think it tells you that although the issues may be the same, the perspectives that we have in the room might actually be quite diverse. And so if we don't listen to all the different viewpoints, we're going to miss out on really important information, not only in terms of policy making, but how do we create meaningful impact on ground. I was also very particularly taken by what Yang Mulia Tun mentioned about the MyC2C. And I thought that was an amazing landmark program because originally it started as a premise of can we teach children about constitutional literacy, about their place in the law, basically about kerakyatan, understanding your place in the country and how the law works. But interestingly, today's child rights discourse, I believe, has moved one step further. So we're not only talking about teaching children and young persons about the law, but also creating mechanisms in which they can help us shape the laws better, especially laws that affect them. So with that, Cherry, what do we have next?
Ladies and gentlemen, now we are going to the next session entitled Good Practice Conducting Comprehensive Legislative Reform. Our session today will be moderated by Dr. Mikiko Otani. Now, it is our honor to call Dr. Mikiko Otani as the speaker for this session. The floor is yours, Doctor.
Good afternoon again. I enjoyed a lot hearing about the sessions 3 and 4. And speakers after the lunch always have the challenge because after the lunch we feel a little bit tired. My session is also very challenging at the end of the long day. So I try to be very brief. I have no formal presentation because we discuss a lot. And my topic is conducting comprehensive legislative reform. I just want to share some of the reflections sitting in this symposium today, hearing a lot, not only from the speakers from the podium, but also from the floor. I heard a lot of very important points raised by the participants in their question and answer sessions. So first of all, comprehensive legislative reform. One of the points I'd like to bring here, I think Professor Tom Learford also used the piecemeal, if I remember correctly, and this is exactly the experience from Japan. In case of Japan, the Japan ratified the Convention on the Rights of the Child in 1994, and so far, the Japan's report was reviewed by the committee 4 times. Every time, a lot of recommendations were made, and some of the recommendations required legislative reform or even new law. And in particular, in the 3rd review and the 4th review, the committee made a specific recommendation to the Japan to consider creating the comprehensive act, comprehensive law for the children. Because in Japan, we didn't have any sort of child act. There was only the law, which is called child welfare law, which is a very old law, and very much perspective about the children are vulnerability and providing the welfare and the care for the children. And there is no concept in the law about the children as rights holders. So what happened in the case of Japan, every time the Japan receiving the recommendation from the committee made a small change in the various areas of law, such as juvenile justice law, or civil law, or family law, piecemeal, a kind of, and also, in my view, minimum approach, only when there is very critical conflict between the national legislation and the convention, there was an initiative for the reform. Why we need a comprehensive legislative reform beyond such piecemeal or minimum approach for the legislative reform? I believe because this was the point raised by Tom, all the children's rights under the conventions are interrelated. So it's not just the one rights and the other rights. And we also discussed about the conflict between the children's rights themselves. But when we look at the children's rights, everything is so related. And we cannot just by amending a little in this area and go to the another area. We need to understand the comprehensive legislative framework surrounding the children. So this is the reason why we need comprehensive legal reform. Another reason I have, coming from the Japanese experience, if we go through piece by piece, piecemeal approach or minimum approach, we only fix certain specific issues without looking into the very core of the issue. And very often the core issue or key issue is the lack of recognition of the children as rights holders. As Ton rightly said, very often in the legislative reform, law doesn't say in the law that children should be recognized as rights holders. And even for the Convention on the Rights of the Child, the convention itself doesn't have any specific provision which says that children as rights holders. How it is expressed? It is expressed by provision. Each provision recognize the rights of the child. So as a comprehensive convention, it clearly recognizes the children as rights holders. So that kind of recognition bringing into the legislation is difficult if we go through law by law or piecemeal approach or minimum approach. We have to consider all the children's related legislation from the more holistic, more comprehensive, and understanding many rights of the children are interrelated. Second point I'd like to bring now is a little bit contradictory to the idea of comprehensive legislative reform. This is the lesson I learned from my friend who is in the government of Japan. When we, as a civil society activist, when I was discussing with my friend in the government how we can implement the recommendation from the Committee on the Rights of the Child, which requires the legal reform. One of the suggestions I received from my friend in the government is civil society sometimes request this reform and that reform. However, also the civil society should be aware of what is happening in the parliament and what kind of initiatives is happening. Because even if the initiatives or law reform discussion are not specifically related to the children, however, that might be the opportunities to integrate some children's rights related to issues in the reform. Because we all know that legal reform requires a time. It's not an overnight event. So if there's some initiative started from this corner around, for example, justice reform, which may not be specifically about the children, if there is any discussion or initiative talking about the legal aid system, it might not be specifically for the children. However, this is the opportunity to hook the ongoing reform process to integrate the child rights perspective. Because one of the issues, I think this came out also very clearly today, when we talk about legislative reform for the children, it's not only about child-specific legislation. Many laws, which are not specifically for the children, actually have impact on the children. So I think as a civil society, and also the parliament, government, the academia, we need to expand our attention to look into any possibilities, any opportunities for any child rights issues to be integrated in ongoing the legislative reform. So this is why I said this point is somehow contradictory to the idea of comprehensive legal reform. I'm saying on the one hand, the legislative reform should go beyond the area by area or law by law. Comprehensive legislative reform is very critical, holistic approach. But on the other hand, we cannot just wait for the whole comprehensive, very big legislative reform process. Whenever and whatever is happening, we should take advantage of ongoing reform process, because children are born every day and the children are growing up every day. So we cannot just go on discussing and discussing. So this is my humble suggestions and talking from the experience in my country, Japan. So that's all, and I hope we can still have some question and answer if there are anything. But from my side, this is what I wanted to share. Thank you very much.
Thank you so much, Dr. Utami. Now I'm seeking the permission of my esteemed colleagues from the Parliament team. Dr. Utami is ready and willing to take more questions. If it is all right, since we are actually 9 minutes ahead of time, we can probably take 1 or 2 questions. Now, Dr. Utami, I thought what you said was really insightful, because it's a conundrum, isn't it? On the one hand, we need to have a structured approach on how we review the laws and the good practices that are there. But at the same time, we need to, I suppose, tackle the bull by its horns and not wait for analysis paralysis, where there will never be a perfect time for everything to fall into place nicely before we're actually able to make changes. And during the lunch break, I had some interesting conversations with the youth, especially when we were talking about online safety and the rights of the child. Very often when we're talking about legislative reforms or access to justice, and the fact that earlier in day one, we were talking about the fact that the jurisdiction or the sovereignty of the local laws very often prevail. Yet, when crimes and harms against children have become cross-boundary, and in such a way that can no longer, in our language it's called dibendung, can no longer be contained by geographical boundaries, how do we then ensure that our laws are not playing perpetual catch-up to situations that are growing exponentially faster than what we can reform? So with that, we've got 8 minutes and 33 seconds. I would like to open to perhaps questions and interjections from the floor. Maybe we can have 1 or 2 questions before we roll to the next session. And Dr. Utami has kindly volunteered herself to answer more. Yes, Silaga, over to you.
Hello. Thank you so much. I just wanted to maybe quickly react to the question about the conundrum, right? How do we sort of deal with 2 things? And I feel for the first one, for the comprehensive review, maybe one of the things that, to the parliamentarian and the legislative actors in the room, maybe one of the things that we may need is a roadmap or a work plan and some strong commitments, right? And this can be done in collaborative with Suhaka, OCC, and others, to have like maybe a 5-year plan where we are looking at law reform comprehensively, especially the existing ones. And I think for the second part, which is the emerging stuff, like the Online Safety Act and other things, I think this then requires consistent training of legislative actors, because I think a lot of times when we see lawmaking processes, as what we talked about, the child rights impact assessment, human rights impact assessment, and a lot of other processes may be quite missing. So I would then suggest these 2-prong strategy. One is for long-term commitments by governments and Suhakam oversight bodies, etc. And the other one to invest in training so that then parliamentarians and state assembly actors then have a better child rights lens whenever they make laws, right? If I may also just like quickly expand on things, I appreciate the fact that earlier we expanded access to justice to a broader perspective, because I do think schools act as a microcosm because they then reflect a lot of broader laws and regulation within school regulations, right? And this is also where we see corporal punishments. So I think in talking about laws and legislative reforms, I think we cannot miss schools, because I think that's where a lot of young people actually experience lack of access to justice. And I think this is also reflected in 2009, a study by Suhakam on transgender people, where they found that actually, you know, a lot of transgender kids and LGBTIQ kids do not actually have access to justice because they don't have a trustworthy and friendly mechanism for them to talk about their issues, right? So we definitely see a relationship between support services and redress. And another barrier that I want to add to this is parental consent, which then act as a huge barrier, right? One last thing before I end. Another barrier that I want to add is that the criminalization of adults and discrimination against adults actually have an unbelievable chilling effect on children. And I think this then has a significant impact on minority stress, you know, and also access to justice, isolation, and also migration. That's all. Thank you.
Thank you. Is there any further questions, reflections? Any thoughts? Yes, Wabi Mumtaz. Can we please have the mic over, please? Thank you.
Assalamualaikum warahmatullahi wabarakatuh, and a very good evening. I would like to know, how did Japan successfully integrate the positive behavioral of their children and at the same time make them very independent? Because all over the world we see that the ethics and behavioral of the children in Japan is very outstanding. And the second thing is, I would like to know, how did you integrate the reforms across the ministries in Japan, and how did you review it from time to time? Thank you.
Thank you, YB. Can we have a mic for Dr. Utami, please? Thank you.
Thank you very much for the questions. Still, we have energy to talk about. I'm very happy. So I will respond to the comments later on, but firstly, I would like to respond to the question from about Japan. So just before coming here, I gave a speech in the morning on Sunday, and so one of the questions I spoke in Tokyo, in Japan, for the Japanese audience, and one of the questions I received there was, what is my perception comparing the children in Japan and the children in other countries? Because the audience expected me to have the opportunity to see a lot of children's situations in many countries as a former member of the committee. And I said that very often the children in Japan seeing very much disciplined, and but it is good or bad, I have to say, because both adults and the children in Japan follow the orders or the self-disciplined. But it means that the children don't feel free and very much under the pressure. So our school education system is actually not creating the children who feel comfortable to speak and express their views very freely, always looking at others and try to be the same as others and to be the safe. So this is how I see the Japanese children. And secondly, about the reform in Japan, Again, I'm sorry that Japan is not a good example in that sense. There is no comprehensive roadmap, and so that is related to the comment from this side. I think having the roadmap for the comprehensive legislative reform is a good idea, because as we all know, the reform takes place, and for the children's issues, various ministries are relevant. So maybe for some issues, the legislative reform requires involvement of more than one ministry, maybe 2-3 ministries. And the leading ministry would be different from issues to issues. So, for example, under the Convention on the Rights of the Child, the frequency of the state parties report is 5 years. However, in the reality, because of a lot of backlog the committee has, the real time lag between the review is now average of 8 years. So like now, the Malaysia was just reviewed by the committee and received a lot of recommendations. So I think it is very important for the government or the parliament to thinking of next like 5 years, how you can create some roadmap depending on the priority in your national context, but also some work which is already happening by Ministry of Ministry. So this is the way, and Japan, we should also need to think about the comprehensive plan. And also I wanted to add one more point. I understand that Malaysia was also reviewed by the CEDAW committee, the Committee on the Elimination of Discrimination Against Women, and also the review by the CRPD Committee on the Persons with Disabilities coming up, and the UPR. So all those things are actually creating the opportunity for the legislative review, and some of the recommendations are the common between the women's rights issues and the children's rights issues and the disabilities. And also today we heard a lot about issues of children with disabilities. So combining those opportunities coming from the international level, such as the various treaties, committees, and also UPR, Universal Periodic Review of the Human Rights Council, are the good opportunity to plan at the national level which issues should come first for the legislative review. So, and thank you very much for your comments and raising the importance of this school issue. I fully agree. This is so much important. And this is, again, the experience from Japan. Not only about the law. Currently in Japan, the discussion is going on about the review of the guidance for the teachers, what the teachers should reach. This is not a law at all. It's a kind of administrative level of guidance. However, it is so powerful. So those civil society who believe that teaching the children about human rights should be integrated and explicitly mentioned in this guidance. And this guidance review happens like after 2 decades. So we cannot miss this opportunity. So these kind of things, I think it is very important. Something happens, and very often we talk about the legal reform. However, it's not a law, but it's so powerful, and we cannot miss the opportunities. And I also heard in some session that the children are not heard, or even if children bring their voices, it is not taken seriously, or something is already done. And after that, they realize that they were not heard. So as adults, we also need to inform the children what is happening, and this is the opportunity, and the children's voice should be submitted to the decision makers. So this is my last reflection today. Thank you very much.
Thank you so much, Dr. Utami, and a big round of applause both to YB Mumtaz as well as Tilaga for sharing. I think it's deeply humbling when we think about what's going on in the world. very often in Malaysia, we have this idea of hujan emas di negeri orang, hujan batu di negeri sendiri. And when we listen to what's happening across the world, what we realize is that there is no one single country that has figured it out. This is an ongoing effort, and it will continue to change simply because the world is constantly changing. Dr. Utami, I believe you also have a saying, "Shireba shiru hodo kenkyo ni naru." The more we know, the more humble we should be. And so with that, I humbly open the session for tea, and I hand it over to you.
Ladies and gentlemen, before we continue with our next session, we will take a short coffee break for refreshment, which are now available at DAY1 Banquet Hall. May I kindly remind all distinguished guests and delegates to return to your seats by 4:25 p.m. as session 6 will begin promptly at 4:30 p.m. Thank you so much. Ladies and gentlemen, as we are about to begin, I would like to request all of you to please be seated again and turn off your phone or put them on silent mode. We will be starting in few minutes. Ladies and gentlemen, once again, as we are about to begin, I would like to request all of you to please be seated and turn off your phone or put them on silent mode throughout the event. Thank you.
I'd like to request the assistance of our ushers and our representatives from the organizing committee to invite our participants back into the hall, as I believe quite a number of them are still having tea. While we have our participants coming back into the banquet hall, can I request for the QR code to be displayed once again for the slides? So for those who are here, you can take the opportunity to click on the QR code that will be shown on screen in the next few seconds, and it will lead you to the contents of the presentations that you have heard today. And it is going to continue to be uploaded up until day 2. So tomorrow you'll also have a QR code that you'll be able to access to be able to check the various different presentations. We have it on screen now. All right, ladies and gentlemen, we are going to begin. For those that have stayed with us until the last segment of today, I congratulate you for your stamina. I know that the day has been long and a lot of very heavy topics discussed. Yet, special thanks to our youths who stayed back. Quite a number of them actually had to take time out from school. There are those that actually came from outside of Kuala Lumpur. So I also want to thank those that came from Sabah, Sarawak, from the East Coast. So that really, goes to show that although it is an issue that is ever evolving and is becoming more and more complex, we're also blessed to not only have people who are captive audience here in the banquet hall, we also have people who are watching us online via the Parliament Online live session. So thank you so much to the Parliament of Malaysia for ensuring that this is happening. All right, with that, ladies and gentlemen, welcome back to your next session of today's symposium. It is by no means less important than the rest. In fact, I think we are upping the ante. The next few sessions are going to get even more fiery, inshallah. The session is made for us to be able to understand the current status of the law affecting children, what's lacking, where we're good at, and what we need to improve. Do our laws fulfill the UNCRC requirements? I think the many sessions prior have actually gone to show that we've made good progress, but we must not rest on our laurels, and there's a lot more to do. So with that, it is our honor to invite Yang Bahagia Datuk Tiago Ganesan, the Deputy Director General of Law Reform and Legal Affairs Division of BAYU, which is the Prime Minister's Department. And for our friends from outside of Malaysia, BAYU also means breeze. And to come on stage for the session to begin. Datuk Tiago. Now, before he begins, we have an intervening session, which is a video playback by one of our child representatives. And her name is Isha. She's a member of the Child Consultative Council of Suhakam, and she will be giving her interjections via video. Over to you.
Hello everyone, my name is Isha. I'm 12 years old. I have Down syndrome. Malaysia should change the Persons with Disabilities Act 2008. This law says that people with disabilities have rights, include the right to go to school, get a job, receive health care, use public transport and other public places. However, the law is not strong enough. It does not clearly explain what punishment should be given when someone breaks the law. This means that people with disabilities may find it difficult to get help when they are treated unfairly. So Hakam has asked the government to make law stronger. People who break the law should face consequences. And people with disabilities should be able to get help and justice. Changing this law may not be enough. Malaysia's constitution should also clearly say that it is wrong to treat someone unfairly because of their disability. The Malaysian Bar believes that both laws should be changed. This will help people with disabilities protect their rights and take unfair treatment to court. Thank you.
A big round of applause to Isha. Thank you so much, Isha. And with that, Dato, over to you.
Thank you, MC. Very good afternoon to the members of this convention, Yang Berusaha Dr. Farah, the Chief Children Commissioner of Malaysia, a very dear friend, and also Yang Berhormat Senators, some of the senators are here, and also Yang Berhormat ahli-ahli Parlimen Dewan Rakyat dan juga Suakam Commissioners, Melissa Commissioners, Dato' I've seen her there. And tuan-tuan dan puan-puan, some of familiar faces from UNICEF, CSOs, and also tuan-tuan dan puan-puan daripada academy side and also from the professional organization. And Your Excellency, Miko Otani, former chair for Child Rights Committee. Nice to meet you here. And my name is Tiago Ganesan. I'm from Legal Affairs Division, Prime Minister Department. I've prepared my dear colleague, Ms. Shafika here. She prepared the slide in Bahasa Melayu because the invitation is sent in Bahasa Melayu, then hence the preparation of the slide is done in the Bahasa Melayu. But anyhow, in between, I can able to share some of the points in both languages to make easier for the audiences here. Next slide. Where's the slide, by the way? Is anyone playing my slide? Okay. Before allowing me to share, setting the scene for this particular platform, particular topic is that CRC. The topic given is actually access to justice and effective remedies. We can see the comments have been made by the Child Rights Committee and also the progress that have made by Malaysian government, particularly Legal Affairs Division. Whatever I have submitting here is actually from Legal Affairs Division lands, and also I've incorporated the agencies under the Legal Affairs Division, which is primarily under the Minister of Law and Institutional Reforms. Is the slide ready? Sorry for the technical glitches. Okay, next slide. First, setting the scene. I mean, everybody here fully understand that penderaan mempunyai pelbagai bentuk dan ia boleh berlaku di mana-mana sahaja. The many forms of violence, physical violence, non-physical violence, and also other form of violence, and also sexual violence occurred in many places. The studio tarian, taman permainan, kawasan perumahan, dan banyak lagi. Itu adalah pertama kita boleh melihat penderaan boleh berlaku dalam pelbagai bentuk dan juga dalam pelbagai tempat. Next slide. Tuan-tuan dan puan-puan, what is important is that kita sedang melihat penambakan kes daripada jenayah seksual kanak-kanak. Dari tahun 2021 sehinggalah Disember 2025, sebanyak 8,259 kes. I ulang, 8,259 kes, 8,259 cases that related sexual offences against children have been prosecuted, have been investigated by the PDRM. And out of this number of cases, 7,237 cases alone under Section 14, which is non-physical assault. And the cases are keep growing here. So when this kind of circumstances in place, next slide. Ini adalah satu topik yang sangat penting di mana access to justice and effective remedy for children. This is the key topic, and we will see, next slide. And when the CRRC of making observation on Malaysia's progress in the year of 2026, they have taken note of revised special guidelines for handling child sexual abuse cases. Thank you for UNICEF for being partner with Legal Affairs Division and other organization in order producing that. And also amendments to the Evidence of the Child Witness Act 2007. It doesn't mean that the amendment made in the year of 2007, but is actually amendment made to the Act itself. what is important here, the committee remains concerned about children's limited access to justice and remedy. And these are the recommendations that committee has given. Allow me to read that recommendation particularly here. Number 1, A, ensure that all children have access to confidential, child-friendly measures and independent complaint mechanisms in schools, foster care systems, alternative care settings, and places of detention for reporting all forms of violence, abuse, discrimination, and other violation of their rights. Number 1, child-friendly reporting procedure, and it has to be confidential, been recommended by CRC committee. Number 2, legal support and age-appropriate information on access to counseling and remedies, including compensation and rehabilitation. Number 3, safe child interviews and forensic procedures to prevent re-traumatization. These are the key recommendations have been given under the category of A. Number 2, B, expand the legal companion services, ensuring it is accessible to all children, increase awareness, referral pathways. The source for this particular recommendation is the Committee on the CRRC Concluding Observation on Combined Second to Fourth Periodic Reports of Malaysia, recently published. These are the recommendations that have been given. Next slide. In this particular slide, next slide please. Apakah itu akses kepada keadilan dan juga remedy berkesan? Access to justice dan juga effective remedies. What are those? It's fundamental questions we have to understand first. And I'm not quoting, I'm actually quoting an important source that a committee, they themselves have come up with actually, draft general comment number 27. In this particular comment, number 1 is actually access to justice, have divided into 3 parts. Primarily, membuat aduan apabila hak mereka dilanggar. Allow them to lodge the complaint. Number 2, mendapatkan bantuan dan perlindungan. It's actually to provide the support system and also protection. Number 3, mengakses mekanisme kehakiman dan bukan kehakiman, legal and non-legal friendly measures to be made available. So that is the part of the ecosystem of access to justice. Next, we move on to the effective remedy. When effective remedy, what are those effective remedy? Number 1, penyiasatan dan tindakan terhadap pelanggaran hak. So when there is a breach, that tindakan dan penyiasatan, that's one form of remedy. Number 2, perlindungan dan pemulihan. It's actually a protection and a restorative. Pampasan and rehabilitasi adalah compensation, rehabilitation, and last one, jaminan bahawa pelanggaran tidak berulang. It's actually to give a assurance that it will not be repeated. So these are the effective remedies that has been classified under draft general comment 27. Next slide. So what is the expected outcome by CRRC? Number 1, mekanisme aduan yang bebas dan mesra kanak-kanak. Kedua, bantuan guaman dan sokongan undang-undang yang mudah diakses. Nombor 3, prosedur dan mahkamah mesra kanak-kanak. Keempat, temu bual dan proses forensik yang selamat. Nombor 5, hak kanak-kanak untuk didengar. Nombor 6, perlindungan privasi dan juga kerahsiaan. Nombor 7, pemulihan rehabilitasi dan juga pampasan. Nombor 8, perlindungan daripada trauma berulang, re-traumatization. So ini adalah harapan daripada CRRC. By having access to justice, effective remedies, this is the expected outcome by the CRRC committees. Next slide. And the same draft general comment 27 also listed down, those are the best practices that under this particular draft general comment 27. And what is the important element, the core principle is this. Kanak-kanak hanya perlu menceritakan pengalaman mereka sekali saja dalam persekitaran yang selamat serta disokong oleh bantuan guaman, psikologi dan sosial yang sewajarnya. The child only allowed one time, not repeated times actually. That is the core principle of this particular best practices that came up with under the draft General Comment 27. With that framework in our mind, let us see, next slide, Malaysia's response to that particular suggestions from the committee. And also, I would like to share, this is from Legal Affairs Division under the Minister of Law and Institutional Reform. Next slide. Tuan-tuan dan puan-puan, ingin saya berkongsi perjalanan kepada undang-undang ini bermula pada tahun 2017, when the then government introduced Sexual Offences Against Children Act, the first independent law to be introduced in Malaysia at that point of time. Let me share a little bit history. I think some of the familiar faces, I think Selvi, Melissa, you were there, and Sharmila, you are here. All these personals involved in the process of the drafting of Sexual Offences Against Children Act. When we were drafting this particular legislation, there was a strong objections from Attorney General Chambers. Just amend the penal code, introduce the amendments into the penal code, it's sufficient. Selvi, you can recall those comments. And then, but the minister said, no, we're going to introduce independent law, sexual offences against children, and make easier to the prosecutor, make a reference to, when it comes to offences with regard to child grooming, child sexual abuse materials, sexual assault, non-sexual assault, and those abuse power in a relationship of a trust. So this act has been introduced. And you know, today, 50% of the cases been investigated by FDRM from this particular act that was saying no. And this has produced a result. And it's protecting what it says, meaning that the prosecutors and the investigators are clear where to fall when the Sexual Offences Against Children Act involved and the offense taken place, and then the prosecution can be commenced, investigation can start. So next slide. Next slide, straight away. So this was the journey that I allowed to share in the 2017. Thereafter, the government with a collaboration with the Chief Registrar Office, introduced Sexual Offences Against Children Court. That happened also in the year of 2017. It was started with one court. Today, we have 83 special court, and 59 out of that courts are fully equipped with the facilities. Only 59. I know you're asking why the rest of the courts is not equipped with the facilities, but it is a progress efforts by the government with the number of allocation that we have to allocate, particularly for the facilities. After 3 years, we allocated for these courts, and after another 3 years, we have to come back to the maintenance. So the government has to pump in some money, different priorities, different concerns, hence taking it slowly. But the fact that remain proud is that we have started with one court, and we have actually now we have 83 courts across Peninsular Malaysia and Sabah Sarawak. And apart from that, 59 with the facilities. What kind of facilities? We have different pathways. We have waiting room for the child to rest and relax, and also to have the video link facilities and etc. Next, in the year 2017 also, the government have introduced Pengujutan Garis Panduan Pengendalian Case. This particular guideline has been introduced in the year 2017. Let me alert, it is mere codification of existing practice. Nothing we improved. We just codified. We created a coordinated network because we have Ministry of Health dealing with the children. We have Ministry of Women dealing with children. We have PDRM, Ministry of Home Affairs, dealing with children. We have Law Minister looking after legal aid and reform with regard to legal reforms. So various ministries looking after various part of the aspects with regard to the children, particularly sexual offences against children. That's why triggered the minister to establish a coordinated network to people to talk each other, A to B, B to C, C to D. That will allow the access to justice faster and also to produce a better effective remedies. but that was only merely codification at 1.0. Thereafter, government introduced amendments to the Sexual Offences Against Children Act. The same act has been amended 2 times, in the year of 2023, in the year of 2024 as well. So if you can see the column number 4 and column number 5, it shows that government continuously having the intention to make the children protections important agenda, that through legislative reforms. And that have taken place when Sexual Offences Against Children Act has been amended. The terminology of child pornography has been changed to child sexual abuse material pursuant to the ECPAT international report that jointly done with Interpol and UNICEF together, and through that recommendations. And apart from that, the offenses like sexual performance, sextortion, sexual, for the purpose of extortion, have been introduced as independent offenses. And for the first time, stop relying Section 4 to 6 of the CPC for the granting compensation, which is, it is only upon granted, upon request by the Deputy Public Prosecutor. Thereafter, amendments are made, order for compensation. That was the amendment in the year of 2023. And we have to salute for those parliamentarians and those senators have supported that reform continuously that brought by government through Legal Affairs Division. And not only that, and we also amended the Child Witness Act, introduced a special hearing, improper question. We stopped to improper question. Allow me to share what are those improper questions. The court shall prohibit any improper question to the child witness which appears to the court to be misleading, confusing, insulting, intimidating, belittling, or no basis, stereotype based of the child witness sex, race, culture, ethnicity, age, or disabilities. This kind of questions will be prohibited by the court. It was introduced in the same year of 2023. Thereafter, the government, in the year of 2024, we have introduced competency requirement of the child witness, very clear, and I know UNICEF and few other members have keep saying that our law is not clear. We want to make sure that competency of the child witness clear. Apart from that, we also have introduced deletion of the corroboration requirement for the no longer, supporting evidence is no longer required. Why it's so? Because most of the circumstances, sexual offenses against children offenses will happen in closed space where there's no witness and no clear evidences. But we don't want just merely without having the supporting evidences, the child witness will not value, and also eventually conviction cannot be secured. Next slide. Thereafter, government introduced Online Safety Act in the 2025. What we introduced in the Online Safety Act, we have classified 9 types of harmful contents. One of those is cyber harmful contents, and the contents that actually vulnerable to the children, cyberbullying, etc. If those contents available and the respective candidate, the respective person can lodge complaint to the MCMC or can lodge complaint to the platform providers to take that content down. That is one part, which is content moderation. When it comes to content curation, we allow the network service providers or the platform providers, they have duty to protect children. When you key in the age of 15, for example, the system will have some form of protection to protect the child. It was introduced. Thereafter, we introduced these guidelines. Anyone have these guidelines? Thank you. I'm glad that one of these audiences have raised. These particular guidelines, earlier I said, mere codification of existing practice, but this is not. This is not mere codification of existing practice. Rather, this is codification of enhanced best practices. We try to change the mentality of the government system, the mentality how to handle the child sensitivity matter. The best interests always become core. If you all have opportunity to take this particular book and open the pages of 11 and 12, it clearly says guiding principles. Allow me to read those. Best interests of child, ensuring fair trial, minimization of distress and secondary victimization, protection of children's privacy, ensuring children effective participation, non-discrimination and inclusion were the guiding principles of enactment of this Garis Panduan. This Garis Panduan again enhanced best practices. We put in place, currently we are working on the training program, trainers of TOT. We're going to train the trainers. The trainers will train the rest of the government agency people so that nothing remain just a book here, but to truly implement these particular guidelines, because these have been updated from the legislation onward. Next slide. Next particular, sorry, no, go back, not next slide. 2025, also government introduced Anti-Bully Act. Of course, some people argued why we should have anti-bully tribunal at first place. But let me ensure this particular act, that Anti-Bully Act, partially enforced in upcoming 16 June, hopefully. We wait for the announcement from the minister. Hopefully this law will be enforced very soon. In this particular law, we have said the school must have all the process in ensuring the bully-related cases to be investigated. To answering the recommendation by CRRC, allow me to read this in this particular act. 17A says that maintains a committee in relation to prevention management of bully case. It's related to school. School will be empowered, school to do that committee. Implement policies and guidelines and procedures. C, very important, establishes an accessible child-sensitive channel and complies with confidentiality of information for any student to report bully case. Isn't sounds familiar with the CRC recommendation of A, where it says confidential is there in order to lodge the complaint. And D, establishes and provide counseling services and psychological support for the purpose of managing and prevention of bully case. E, provides training in relation to the prevention and management of bully case as may determined by the educational institution and achieve the standards of compliance in relations to the prevention and management of bully. This is provided under this particular law. Not only Section 17, we have Section 31 that says that special procedures to be followed when the child is involved. We have named it, all the details here. Next, in the year of 2006, I have received a copy. That copy is confidential, not to be circulated to the public, only meant for judges. There is an e-bench book has been introduced. Every judges, when they decide, there is a book that have listed all the cases and the recent developments on the site together with the judges when hearing the cases. And currently in the year of 2026, BAYU in the midst of amending Section 3 of Sexual Offences Against Children Act by expanding Section 3 to allow that extraterritoriality, to allow more wider protection for the children. And also currently we are undertaking research with regard to Section 97. These are the reforms that BAYU have done together with many other agencies, not solely from BAYU, but many other agencies supporting the agenda. Next slide. Next slide. Next slide. I want to skip this slide. Okay, I've spoken the differences between the Garis Panduan 2017 and 2025. Next slide. And there was a constant trainings have been given. Next slide. Coming back to the CRRC recommendations. Having this, initially we understand what is expected by the CRRC, and Malaysia has responded, what are the progress thus far? And coming back to the same questions, and you people here evaluate what have we have achieved. I mean, although it's not perfect, Your Excellency, Miko Otani have said, reform should not go by area. It's comprehensive reforms and not solely with one ministry. So it has to be coupled with other ministries together. So let me put it here. People have to work together in order to achieve this bigger agenda of legislative reforms, comprehensive. All parties play an important role. With that regard, next slide. Every child deserves to be heard, protected, provided with an effective remedy. So here we have produced certain form, it's not comprehensive, certain form of progressive reforms from Legal Affairs Division. With that, I thank everyone for listening me carefully. And please, if you have any questions, please put it to me.
Thank you so much, Dr. Tiago. In the interest of time, I would like to invite you to please be seated. We are going to Dr. Faranini first, and then, inshallah, if there are a few minutes to spare, we will go to question and answers combined for the both of you.
Thank you.
Terima kasih.
Thank you.
Dr. Faranini? In the meantime, Cherry, you were thinking of something earlier. So when Dato was talking, we were furiously having a sort of a Law 101 class. So I'd like to defer to Cherry because she had some observations before she introduces Dr. Faranini. Over to you, Cherry.
So actually, I'm having a question about how do we avoid re-traumatization when often children is not always believed to adult, and they have to repeatedly imagine the trauma for adults and take heed and also listening. And you also said reintegrate and rehabilitate, but how do we do this effectively for a young offender? So it's like what's happening when the victim and offender are both children. It can be bullying cases, including the sexual offenders against children.
So thank you for that. I think that kind of frames this. Very often we think of children as just the victim, but we have moved very far from that now. We've seen young offenders, but when we talk about rehabilitation and reintegration of young offenders or anybody really into society, how do we ensure that our laws are robust and comprehensive? Without further ado, shall we invite Dr. Faranini to give her interjections?
Yes.
Thank you very much. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi ta'ala wabarakatuh, and very good evening to everyone. I'm standing here in between you and going home. So I promise you I'll make this short and sweet. The topic given to me was actually to deliberate on the assessment post-CRC review. And if you were to look at the document concluding observations, you will see that there are many, many areas of concern. And it is not my place here today to deliberate on those concerns, but I will be focusing on 6 main concerns. Number 1, withdrawal of reservations. Since we became a state party in 1995, we have had a number of reservations and we have withdrawn a number of them as well along the years. However, we have remained with 5. Now, the reason for this is mainly because Malaysian government takes the stance that until and unless our laws are more or less in compliance with the requirement of the provision, we will remain abstain or remain reserving those provisions. Well, really, I do not think any country in this world comply to the conventions 100% in perfection. But the spirit is that we do not reserve because we should make the provisions as our target. And I stand here today believing that at least 3 of these reservations can be uplifted. One of it is actually on Article 2 on non-discrimination. We reserve this because obviously we have some affirmative action provisions in our constitution, but really other countries have them too. So what we should do is to remove this reservation and work towards treating children in the best interest in whatever capacity that they are. Secondly, we also reserve on name and nationality, Article 7. We reserve this because we do not give citizenship as of right. But how many countries in the world actually do that? So really, we can also remove this reservation because we have amended our laws and make it in the best form that it is now. Of course, there are improvements to be made, but major amendments were made last year. So really, we are in the right pathway. So it is time to remove that reservation as well. The third one is on Article 14, freedom of thought, conscience, and religion. This one we reserve because there is a Supreme Court decision that says that until a child reaches the age of 18, he or she cannot choose his or own religion. Now, this one is quite challenging because of the position that we're in, because of the multiracial, multi-ethnicity that we all come from. I do not see that this will be in the near future be lifted. Number 4, we reserve Article 28(1)(a) on the right of free and compulsory education to all children. We reserve this because our Education Act only provides that free education and compulsory education only for Malaysian children. Again, we should lift this up. Why? Because I know some of the MPs here today actually offer free education in their own constituents. So in other words, we are all striving to provide education to all children in the best of our capacity. So why are we reserving this? Because, ladies and gentlemen, when we reserve, it goes to show that we don't believe in those articles. And surely this is not the case. And finally, we also reserve Article 37, which is the article against all inhumane and degrading punishment. We remain reserved because we still have caning in school. We remain reserved because although we have abolished whipping in the civil courts, we still have provision in the Sharia courts which allow, not in Sharia court, in the Sharia enactments, which do allow whipping of, although with a light cane, to offenders against Sharia offences. So those are the 5 reservations, and I think we are in the right path towards removing most of this reservation. Secondly, legislative harmonization. As we all know, in Malaysia, we are subjected to 3 types of laws, although 2 main ones, civil and Sharia, but we also have in certain instances, like private laws, we do have indigenous communities observing their own customary laws. Now, sharing the experience of the Office of the Children Commissioner of Suhakam, we are in the process of wanting to harmonize the laws on child marriage, for example. Last week, we had a successful national muzakara with all state authorities representing the religious authorities. And I'm happy to report that the feedback that we get to raise the marriageable age to 18 has been very, very positive. And next Monday, we'll be going to Cebu. We'll be meeting over 300 leaders of indigenous communities, also to bring the message that raising to 18 is indeed in the best interest of children. Because by doing so, we will keep children in school, we will empower them with skills so that they will not be victims of, to just name one, domestic violence, poverty, perpetuating the circle of poverty, etc. So legislative harmonization is certainly needed because we do not want children of different religion facing different disparity in laws affecting them. Thirdly, child-focused budgetary. This is not in our hands, unfortunately. Strides have been made. You have heard to Datuk Tiagu. He has mentioned all the developments that have taken place. It takes political will, definitely. But you also heard what YBOBN said in the morning, that conversation on children in Parliament is actually less than 1%. So I shall not say more, but definitely, if we talk about putting children's best interests, the budget has got to be there as well. Because at the moment, children fall through the cracks, despite having one of the most comprehensive legislative reforms in the world. And I dare say that because I've been in this business for 33 years. But until and unless we do not have institutional reform, until and unless we do not empower our social work profession, we will only be having statistics after statistics of children falling through the cracks, despite having laws as early as 1922, then 1947, then 1991, and ultimately 2001 in the Child Act. Fourthly, data collection. This goes without saying that we need to have integrated, disaggregated national data so that we know what to address. In my own experience, in the short 3 years that I've been the Children Commissioner, when we want to advocate for anything, our main weapon will be that of anything that's evidence-based. And for something to be evidence-based, it has got to start from data. And because I'm sitting here in this August House, I would like to call upon members of Parliament, let's start at each constituency. Before we say, oh, we don't have a national data on child abuse and neglect, we do not have a national data on actual child marriage, why not every one of the 222 constituencies that we have now, for every member of parliament to keep track of what is happening on their constituency? We can support. But if we start at every constituency, then only the mechanisms that has been established in the Child Act since 1991, in the Child Protection Act, to name one, the Child Protection Team, can actually be activated. Now they exist only in name. Child welfare teams also exist only in names. I know some of you say, oh no, in my community it's working very well. Again, it just boils down to child protection in Malaysia is so much champion-based. It depends on who is there. It depends who is actually at the forefront. And we cannot have this for children of Malaysia. We cannot have this for any child in the world when it is only champion-based and it's not systems-based. I dream for the day when children in Malaysia will be getting equal treatment no matter what happens to them. It may not be during my lifetime, but I'm really banking in our young people in front of us now. It is not enough to have legislative reforms. We've been hearing that 3/4 of today. What's more important is that, do we have what it takes to turn the spirit in the legislation into pragmatic actions? Enough mechanisms, but what good if we do not have the resources to run those mechanisms? There are good people in this country, and there are many, many good people in this hall. You all are, many of you are unsung heroes. We all know that. But we need to cultivate more heroes and more champions for children. And fifthly, access to justice. This has been spoken enough. You heard from the former Chief Judge herself. Access to justice has, of course, improved in leaps and bounds. But you also heard from our lawyer just now that although we provide access to children, but do they really get justice prior to that, in between, or when they reach the court? Realistically, not all of us respect children as rights holders. Let's not talk about rights holders. Let's talk children as human beings. Children are not miniature adults. They are persons of their own rights. But frankly, I think, sadly too, children in this country are still objects of concern. Why do I say this? Because we often talk about them as though they cannot make meaningful contribution into the discussion. And in our experience at the Office of Children Commissioner Suhakam, every time you include children, chances are what you do will be 100 times better. This is no longer the time to say, oh no, we know better. Excuse me? When we were doing, when Bahayu was drafting the anti-bully tribunal, the Anti-Bully Act, we had included children in this very same hall. We had included children also in the town halls. And their recommendations were actually included in the act in the long run, in the final run. And it's more meaningful because it's their voice. Why do we have the tribunal in the act when I know many advocates of children's rights do not agree with the tribunal because seemingly it sounds punitive. But then again, the children wanted something beyond the schools. They say that they needed something that if they were to complain, action will be taken. They want true action so that they are not afraid to go to school anymore. And that was the result of why we have what we have in the Anti-Bully Act. It's not due to our whims and fancies. Who would want to spend more establishing tribunals across the country? It's not as though we have so much money, right? And finally, on access of justice, I would just like to conclude with this point. Every time children reach out to me, my fellow commissioners, to CSOs for help, Dr. Hartini is one of them, the common one, we always wonder, what happened to those other children? Because when we say we have to intervene on their behalf, it really means we have to intervene. We have to look for lawyers for them. We have to make sure that they know when the hearing dates are. We have to remind lawyers as well. And then we wonder, what happened to the majority of other children? Do they get some form of help, really? Or are these high-profile cases that come to our attention, that we are reaching out to, that really get our assistance? Chances are they are not, isn't it not? And finally, independent monitoring. We have not done too badly in this department. Since 2019, the government has established the Office of the Children Commissioner, with Dr. Azia as the first commissioner, and I followed after her. And fortunately, 2 more commissioners were added last year, Dr. Zulfa and Dr. Adib. And so we do have a system on that. But having 3 commissioners looking after 30% of the population is certainly not enough. Why Mumtaz was telling me that we should have children commissioner in every state. Of course, that would be lovely. But we tried to establish an independent children commission for that purpose. And it was an aborted mission. You recall that, don't you, YB Mumtaz? And we went all the way to Australia and New Zealand trying to learn from the experience from other countries on establishing independent mechanism independently. But well and fine, we are within the Human Rights Commission and we get support in other assets. And I don't think that's such a bad idea in that sense, because we get to streamline, mainstream children's rights in all other aspects of human rights. However, I'm not sure about establishing an independent ombudsman for children, because at the moment, our 4 mandated roles do cover that of addressing complaints and monitoring, because our 4 mandated roles is that, number 1, to advise the government on any transgression of human rights. Number 2, again, to advise the government on the accession to international treaties. Number 3, the promotion of human rights, and this is our main core business. That's why we are also singled out in the Anti-Bully Act and also in the Online Safety Act. It's our duty to promote child rights. And finally, of course, and complaints and mechanism. Before I leave the stage, I have one question to pose to all of you, for you to ponder. You don't have to answer me. I'm not putting on my lecturer hat today. In this whole spectrum of child rights and child protection system, where do you stand? Are you at the spectrum of empowerment, teaching people of human rights, empowering children, giving trainings? Or are you in the intervention part, whereby you intervene in cases, helping to manage? Or are you in the reintegration part? You were talking about children, the lawyer was talking about children who come into conflict with the law. What happened to them afterwards? What happened to them after they come out from Henry Gurney School, for example? Who looks after them? So in any social problems, there are always 3 stages: prevention, management, and the aftermath. The question to be asked of each and every one of us is, where do we stand in this whole spectrum? Thank you very much.
A big round of applause to Dr. Faranini. Spoken like a true champion of children, right from the heart. Now, in the interest of time, I wish to perhaps open the floor for a maximum of 2 interjections of questions. So please ensure that you state your name and your question as succinctly as possible, to also allow for other participants to proceed with the rest of the day. Jill, over to you.
Thank you very much. I'm Jill Raja, and despite how I look, I'm from Sarawak, the women's group there. And I would like to come back to Datuk's closing statement of that children need to be heard, protected, and provided with an effective remedy. And also Dr. Farah's pertinent remarks about resources. So my questions relate to child protection, and in particular to the CRC expert who asked for social workers in the public sector to be included in the social work bill going forward. So in fact, really I'm thinking there are 3 areas, one now, one middle term and one long term, all linked to improving child protection. So my short term would be, how do we overcome the challenges and how can we work across ministries and including AG and JPA so that the public sector, it's mandatory for child protectors to be qualified social workers in the near future, not some distant unspecified time. So that would be my now. My middle term would be, how can we make the recommendation about child budgeting become a reality? I've lived in Malaysia 40 years. You know, we've come a long way. No mention of child abuse at all when I arrived here in 1985. What has remained is JKM is still the Cinderella department, still under-resourced. Malaysian doctor referred to it as touch and go, child protection services. I think if we had child budgeting, and we see how much goes into child protection again. And also, remedy isn't just getting through court. When a child's been abused, it's about working with them for a long time. And the last point comes back to the excellent guidelines that have been produced, and congratulations to all involved on that. But are there any plans for revising so we have a chapter on the young people who are being prosecuted under the law? So that links back to the question earlier from the co-chair. Thank you very much. Sorry to take so much time.
Thank you, Jill. Let's proceed to the second question and answer them together. Over to you.
Okay. Good afternoon. My name is Tanam. I'm from the Johor Women's League, so I'm from Johor. I really appreciate the presentation from Dr. Tiagu. I think it's very nice. It's very good. I think we're aiming to get somewhere. However, my question is enforcement. So I take the point of Dr. Mikiko. I think this piecemeal approach is, it has to be comprehensive. Recently in Johor, we had a case in Pasigudang. An 11-year-old student was groomed by the school teacher, and then she's 12, and police reports were lodged. And then somehow or other, the family in Johor, but the family was a Sabahan family from the labor classes. At some point, it was dropped because the teacher promised to marry the 12-year-old when she turned 18. Okay, and it was and 2 reports were lodged. Now, here, it's why I highlight this case, and it's painful for child activists who have been working, creating awareness and trying to talk about all the amendments to the law, and then we are trying to battle digital abuse, when even at a practical level, it is not one department that failed. So the education department failed because they took the teacher, kept him in somewhere for 3 months and put him right back at the same school. And all parents are unhappy, all teachers, made the principal unhappy. Every school has a pegawai perhubung sekolah, so the police are involved. None of it could have happened without 2 or 3 departments not following SOPs. So if there's no enforcement, Dr. Mikiko's point is true. It has to be institutionalized justice. And Dr. Farah, you are going to do it in your lifetime. There's no such thing as deferring it to the young. We have to do right by the kids. Great at the policy level, and I'm sure you're doing your best to train the stakeholders. It has to go to the ground, because that Pasigudang case, it must be a painful fork in your faces, because I don't think that even the D11 at Johor level knew about it, and definitely the JKM child protectors were not involved until the case was viraled. So viralizing is a weapon used in the face of poor enforcement. And then in the middle of the night, I was messaging YB Mumtaz, because YB Tumpat, because what are we going to do about this? What are we going to do? So we have to do better. We have to do better. Enforcement.
Thank you very much. Now, I'd like to defer to our esteemed panel to perhaps share their thoughts.
All right, very challenging questions. What do you expect? First of all, the lady, thank you for posting 3 important questions. And with regard to the bill, the currently in the midst of KPWKM's purview, by telling KPWKM's purview, I already answered your question. I can't answer that particular subject matter. Number 2, child-friendly budgeting. I share the same view what you have presently. And of course, this is not my pay grade to allow to make that decision. Any recommendation comes to us with regard to that idea, you have my support from Legal Affairs Division, but it is the Cabinet and the Prime Minister, the Minister in charge political will. I think that only can make that as a number 1 priority. And government, in the midst of having so many priorities, and some of these ex-civil servants are here, you may know how things worked and how things working and how priorities keep changing. So I really hope that one fine day, and as soon as possible, this will be one of the important priority. Number 3, with regard to the guidelines, we made our mind very clear at that particular point of time. We focus on the child sexual offenses against children victims. I do agree we should look into it to expand the scope. We will come there. We will take it. If you could come on board to support, I think UNICEF already written to Legal Affairs Division to look into this angle, and they specifically quoted your name to bring that reforms. And thank you, lady. You have sorry, Danam, Miss Dalam. Correct, okay. Thank you. Sorry. Get to know you from this particular platform. And these questions, very famous questions. In every convention, we hear these particular questions of enforcement. And I think Minister Azalina is very, very, very particular. And whenever we make a law, whenever we make a Garis Panduan, the first thing, don't embarrass me. Don't embarrass me putting so many laws and implementation you all never do. So I think it's very fundamental questions. And how we improve this issue. When we introduce a law, our intention is that we coordinate. And the people who, I'm talking a real experience in my case. In 2017, the team did that particular reform not exist anymore. The new set of people, officers already came into the picture. And the new set of people, in order for them to understand what is the rationale, what is the best practice, what is the intention, what is the spirit, for them to reach, they will transfer. That's how the system works in this particular government cycle. But what things have improved. Not to say that not at all improved, things have improved. You people, be the voice, have made the government sector realize how importance and make effect to the law that we draft, the law that the parliament passed to make into a reality. We do agree there is some challenges. But what in our perspective is that we keep doing the implementation exercise in order to effectively, through proper trainings, through educating the government officials, and also to create the awareness. But things have progressively moving, and I hope, I'm sure my answer will not satisfy you, but somehow rather we hope and pray things can get better along the way. Doctor, I pass it.
Okay, thank you. Jill, you asked the very question that I told you we will not be able to answer on the social work profession bill. And we were all in the same team together. We know what we want. And the thing is, everybody in this room knows that to protect children, the main agency must be skilled, right? But then again, it's out of our hands because it's under a different ministry. But advocate. You know, with the mandatory death sentence prohibition, 10 years ago, we never thought we'll ever be able to do something as drastic as that. But advocate, educate. Finally, it was passed. You see, so we mustn't stop. Likewise with education for non-Malaysians, you know. Now we are getting a lot of backlashes and setbacks. But then keep on advocating. OCC has published this policy brief. So this is our tool. So that's why I was asking the last question just now. Where do you stand in all of this spectrum? Because all of us must do his or her role. Because it takes a village to raise a child. That's the reality of it. And coming back to Tanam's question, that's right, Tanam, we are definitely not going to wait. When I say to change how thinking about children, definitely has got to be the next generation, because that's how with corporal punishment as well, isn't it? It takes generation to actually get rid of it. But then again, with regards to sensitizing officers and all that, what Suhakam has done in the limited capacity that we have is that we train. You know, we provide trainings at the police schools, we provide trainings at the immigration schools, because we have to empower people with this knowledge of respecting human rights. Only then all these guidelines will be able, you know, to be executed in the way, in the manner that the spirit why it was created. I think that's all. Thank you.
Thank you very much. A big round of applause for both Dr. Tiagu and Dr. Faranini for being brave to answer the questions that were brought up. And really, it bears back to the reflection that when she says it takes a village to raise a child, I do feel that there are many other stakeholders that are meant to be here, whom perhaps are not as privileged as we are today to be part of this conversation. We had earlier discussions on social workers, but we have not even touched on medical social workers or assistant child protectors or court advisors and the whole host of people who are also part of the child protection system one way or another. And it also starts with all of us. So I'd like to invite you back to your seat. Thank you very much. Now, at the same time, ladies and gentlemen, do not feel disheartened. This is only day one. You've done really well. I hope you come back home, rest and recoup, and then really boil down some of the sharings that we've had today and come back with more questions on day 2. But do not leave just yet, because we have a closing remark. And Cherry?
Now, congratulations everyone. We have now concluded day 1. What a day full of knowledge, sharing, and wisdom. Now, we would like to conclude all matters of day 1. And for that, we invite Ms. Jaskirat Sohanpal from Kemban Collective to wrap our day up. Dipersilahkan.
Hi everyone, thank you so much for your robust participation today. I know the sessions were really informative and a lot. I just wanted to reiterate a few things before we leave today. You can scan the QR code of the pocketbook that we will be launching tomorrow. It is the pocketbook to strengthen children's rights through the Malaysian Parliament. When we launch it tomorrow, we will give everybody a copy. And we hope that you can see how the pocketbook can be helpful to you through the sessions that have been done today and tomorrow. Tomorrow will be another full day of learning and sharing with 6 different sessions. And I hope everyone will show up with the same amount of enthusiasm as you did today. We will begin at 9, and we will start with an overview of Malaysia and a comparison with other countries. Then we will discuss some good practices in Southeast Asia. We will then move to what makes a city a child-friendly city, followed by what improvements can be made to the Child Act. We will break for lunch from 1 p.m. to 2:30, and then jump right back into our next 3 sessions. We will discuss rights to identity, where we will discuss children without documentation, children who are migrants, and children who are stateless. Then what are our local approaches to alternatives to detention? Finally, we will be talking about addressing harmful practices through legal reform and human rights monitoring. Here is where we will see the intersections between CRC, CEDAW, and UPR. All of the key information from these sessions will be reflected in the pocketbook to strengthen child rights through the Malaysian Parliament and support all of the sessions that we go through tomorrow. Please stay for the session, for the launch tomorrow. It'll begin at 5 and will be graced by YB Tan Sri Speaker, Datuk Johari bin Abdul, and YB Lim Hu Ying, Deputy Minister of Women, Family and Community Development. That's it. Thank you so much, everyone, for your attention, and see everyone tomorrow.
Thank you so much, Jaskirat. Now, you see the QR code. Before you leave, please ensure that you scan the QR code and share with us your feedback for day 1. There's also a QR code that will lead you to all of the different presentations for today. So that without further ado, on my lovely Cherry and Nadia, thank you so much for spending time with us today. All the best, safe drive home, and we'll see you tomorrow. Assalamualaikum warahmatullahi wabarakatuh.
Thank you so much to everyone. I hope you guys have time to come tomorrow, and just that from me. Session terakhir. Session terakhir. Sebab dia cakap dari hati, dia cakap dari segi dia punya.
Oh, okay. Sorry, Team Parliament, can you tunjuk balik QR? Can you show the QR again? Thank you.
Session 6 paling berkenan.
Patutnya kalau session 6 tu dinaikkan ke atas, ada lagi banyak orang yang dengar.
Yes.
And I think it's also sebab mungkin Dr. ini mungkin tak free awal, and then diorang kena lepaskan all the kedutaan dulu, tu sebabnya dia last. Tapi kalau you letak dia dekat atas,
I'm sure everyone knows.
Masa you masukkan dia sesi pertama lepas lunch. Jangan bagi, maksudnya atas dia okey lah all